We are live.
Hey, how are you? Nice. Good morning. We are back in Senate Judiciary on April 15th, and we're taking up page 385. We have Ledge Counsel in the Zoom with us to provide a walkthrough. It's my understanding there's some parts that are not judiciary related, so we'll try to stick to safety. Maria, can you hear us?
Yes, I can.
Thank you. So sorry we got a little late start, but the floor is all yours.
No problem at all. So is everybody ready, or you need another minute?
Oh yeah, we're good to go. You got it. You all have a bill in front of us.
Okay, terrific. So I'm Maria Royal with Legislative Counsel. So we're going to walk through H385 as passed the House. There are actually two substantive provisions. The first section deals with coerced debt, which I'll explain momentarily. And then the other section is concerns banking provisions, particularly regarding the protection of customers from potential financial exploitation. So those are the two big substantive provisions, and then there's some reporting requirements. So I'm going to pull up the bill. Now, would you like me to share my screen, or do you want to just keep working from your?
If you don't mind sharing your screen, that could be.
Yeah.
Thank you.
Sure. Okay. Okay. Let's see here. All right, so as I mentioned, two substantive provisions. The first one concerns coerced debt. So briefly, just a pretty quick overview before we get into the details. Coerced debt is something that applies to survivors of domestic abuse or human trafficking, or the abuse, neglect, or exploitation of a vulnerable adult. So these are the potential victims or debtors who, if they are subject to coerced debt, would be able to take advantage of some of the remedies and protections here. The coercion element is defined, but basically if one of those individuals has their personal information used either under threat or fraud or unknowingly to incur debt in their name, that there would be some protections available to that person. So that's just kind of a broad overview, but we'll go through the definitions first, and I'll kind of explain the context in which they come up, which will become more apparent when we actually get to the substance. So with respect to adequate documentation, a big component of this bill concerns what a creditor does. So the person who issued the loan, if they're presented with a statement of coerced debt by the debtor, as well as adequate documentation, there are specific procedures that they then would need to do. So this is the definition of what that adequate documentation includes. It means one of the following, at least one of the following: a copy of a report filed with federal, state, or local law enforcement that identifies the coerced debt and the circumstances under which the debt was incurred, and the filing of which subjects the person to criminal penalties for filing false information if in fact the information in the report is false. The second form of adequate documentation is a court order finding that the debt was coerced, or a sworn certification from a qualified third-party professional regarding the debtor's claim of coerced debt. And there is
Maria, we have one question in the room.
Sure.
Sorry, Maria. I just thought it was better to put this question here. So I'm wondering, I read it as any of those three qualify, and I'm looking at the first one. So I understand that there's a penalty if the information is false, potentially. But does this say that a person just has to self-certify that their debt was coerced?
That's a great question. And there's another definition about what statement is required for the coerced debt. And you'll see under the definition that that statement by the debtor has to either be notarized or they self-certify. So they're given an option.
I guess I don't mean notarization as such. I mean, they themselves attest to the court that it's been coerced. Is that enough, or later in the process, are there other standards of evidence that need to be met?
Okay, so so maybe I misunderstood your question. So were you specifically, in terms of the adequate documentation, were you referring, I think you said this in the beginning and I may have misunderstood, to this specific court order that's referenced here, or the report filed with law enforcement?
I'm looking at line 9 through 13.
Okay. Okay.
And it says copy of a report filed.
Yep.
And I'm wondering, is that report, who generates that report and from what evidence?
Okay, my apologies. Yeah, so this would just be a police report, essentially.
Okay, so there is a independent law enforcement representation of events.
Yes.
Great.
Yes. Yeah, I apologize.
No.
I misunderstood the question. So you'll see there is the definition of what a coerced debt actually is. So it means all or a portion of secured or unsecured debt solely or jointly in a debtor's name that A was incurred. Yep.
Maria,
One more question.
I'm sorry, just going back to that paragraph. The last clause of it says, filing of which subjects the person filing the report to criminal penalties for filing false information. To me, that doesn't sound like it's a police officer. It sounds like it's a report filed by an individual.
Well, I think it would be, there is a criminal provision that applies to false reports to law enforcement. So if it was later determined that the police report was premised on information that was not accurate.
But it says the person filing the report.
The filing of which, so the person filing the report is the debtor who files a police report, right? So
I mean, I don't think a witness filing the report.
okay, a copy of a
We'll just flag it and come back to it maybe.
okay, I'm sorry if I'm misunderstanding. Yeah, happy to give this some more thought.
Okay.
So the debt was incurred as a result of domestic abuse, human trafficking, or the abuse, neglect, or exploitation of a vulnerable adult, and those terms are defined later on. And the perpetrators, 1, use of the debtor's personal information without the debtor's knowledge, authorization, or consent, or 2, use or threat of force, intimidation, undue influence, fraud, deception, coercion, or other similar means against the debtor. And then there are some exceptions with respect to the debt. It does not include a mortgage loan, nor does it include a commercial loan. So, an accreditor for purposes of this bill means a person or the person's successor, assignee, or agent claiming to own or have the right to collect a debt owed by the debtor. Then, as mentioned earlier, a debtor for purposes of this bill means a person who owes coerced debt, is a survivor of domestic abuse or human trafficking, and is a vulnerable adult who is a survivor of abuse, neglect, or exploitation. Domestic abuse has the same meaning as in Title 15 concerning domestic relations and protective orders in the context of domestic abuse. Happy to look at that more closely if you would like, but I think this committee is probably familiar with some of those terms. There is a definition of future abuse, and that will come up in the context of if a debtor is asked to provide contact information for the perpetrator of abuse and does not want to do that out of fear of potential future abuse. Good faith, there's a definition of good faith as that term comes up with respect to the creditor's actions upon receipt of a statement of coerced debt. And basically the reference is to the definition of good faith under the Uniform Commercial Code. Human trafficking, again, just the existing statutory definitions of human trafficking and aggravated human trafficking. The perpetrator of coerced debt is the individual who causes or is alleged to have caused coerced debt to be incurred by another. And then in terms of the qualified third-party professional, who might be working with the debtor and who can file a statement on behalf of the debtor. Those individuals may include, provided they do not have a conflict of interest. Yeah. Go ahead. Is there a question?
No.
Okay, sorry. An officer of the court or law enforcement personnel, a court-appointed special advocate, a crisis worker as defined in Title 12, who is employed at a program that assists survivors of domestic violence, sexual assault, stalking, human trafficking, or abuse of children, and who has relevant training or expertise, a licensed attorney, a healthcare provider as defined under Vermont law, and that's it. So these are the individuals who could submit a statement. So then in terms of what is included in that statement, more specifically, first of all, it needs to be a sworn written statement by a debtor, provided by mail to a creditor that includes the following information: identification of the debt or portion of the debt alleged to be coerced debt. If available, a description of the circumstances under which the coerced debt was allegedly incurred. A statement by the debtor disclosing that the debtor did not willingly authorize the use of the debtor's name or personal information to incur such debt. Any information known by the debtor, including account information or credit card information, and if applicable, the name of any other individual in whose name such debt was jointly incurred. The identity of and contact information for the perpetrator, if known, unless the debtor signs a sworn statement that disclosing such information is likely to result in future abuse to the debtor or to a member of the debtor's immediate family. The statement shall also include the debtor's preferred language and contact method and information such as a telephone number, email address, and physical address, or safe address for either the debtor or a third party whom the debtor designates to receive information about the coerced debt, which shall be specified by the debtor, and any other documents the debtor deems appropriate to support the statement. And then there's just a definition of what mail means. Certified mail, certificate of mailing, or any other similar first-class mail tracking method used or approved for the U.S. Postal Service, including intelligent mail barcode tracking, which enables real-time tracking of mailing. The term also includes any electronic or digital transmission that provides a verifiable date, timestamp, or tracking capability. And then, as mentioned, a statement of coerced debt shall be notarized or shall include the following language, which is basically the self-certification language, declaring that the information is accurate and any false statements are subject to a penalty of perjury. So then we look at the sworn certification, and this is the certification that the third party professional can submit, which would qualify as adequate documentation. And I apologize if I actually referred to the statement earlier, the debtor statement, as the sworn certification. I think I may have confused that, but so basically this is just model language. It should be in substantially this form, which reviews all of the requirements and the definitions that we talked about in terms of what coerced debt is. And then significantly, it has to be based on the determination, must be based on face-to-face contact through an electronic medium, or it could be in person or through an electronic medium. A determination must be based on professional interactions with the debtor and information presented to the debtor or to the professional in their professional capacity. And they must form a reasonable belief to believe that the debtor is a survivor of domestic abuse, human trafficking, or exploitation as a vulnerable adult. And then just a statement that they believe that the circumstances as presented to them suggest that the debt was coerced debt, and specifically identify the debt and portions of the debt that were coerced. So then we get into the main substantive provisions, and I should mention, I don't think I mentioned at the outset, that all of these provisions are a new subchapter under Vermont's Consumer Protection Act under Title IX. So it is subject to all of the rights and remedies under the Consumer Protection Act, including potential investigations and enforcement by the Attorney General. So I just wanted to make sure that was clear. So under this subchapter, there's a statement that on line 13, beginning on line 13, that coerced debt is prohibited. A person shall not cause another person to incur coerced debt, and substantiated coerced debt is not enforceable against the debtor. So then in terms of potential protections and remedies, the section that deals with the creditor's conduct upon being presented with a statement of coerced debt and documentation. What this is getting at is the creditor's response, either ceasing collection efforts or potentially notifying a credit reporting agency that the debt is coerced debt, so that it's no longer on the debtor's credit report. So there is a time, and please let me know if you want to go faster or slower through some of these provisions,
We can
whatever.
go a little bit faster if that works.
Yep, no problem. So there are timelines in here about how quickly the creditor must respond to the statement and receipt of the information, conduct a review and investigation based on the information provided, any other documentation in the creditor's file, just ensuring that the creditor informs the debtor if they did not submit accurate information, that they have a model form, which is very specific, and it is also included in this section, which contains all of the information that needs to be submitted. So essentially, within 30 days, the creditor makes a determination about whether they find that the evidence supports a determination that the debt was coerced. If they do find that it was coerced, they would cease collection activities, and as I mentioned, notify the credit reporting agencies to remove any adverse information. If not, if they find that the evidence doesn't suggest that, the creditor can cease or can recommence its collection efforts, but it may not sell the debt. So it has to keep the debt in the event that there's additional litigation or enforcement. So I won't go through the model form. It's basically intended to adequately inform the debtor of its responsibilities in terms of gathering appropriate information in a way that's not in legalese. So then we get to the section on civil legal remedies, which is probably one of the sections that this committee is most interested in. And I'll just mention that House Judiciary did not have possession of this bill. However, they did take a considerable amount of testimony and worked with Michelle Childs in particular, and communicated their recommendations to House Commerce, I believe all of which were incorporated in the final draft voted out of Commerce. So with respect to those civil legal remedies, so a debtor shall not be liable to a creditor for coerced debt. And then subdivision A2, if the creditor initiates an action to collect the debt from the debtor, what this provision specifies is that the debtor may establish a prima facie case that the debt is coerced debt by submitting the statement of coerced debt as well as adequate documentation. And what this would then do is shift the burden of proof to the creditor to prove by a preponderance of the evidence that the debt is not coerced debt. So if ultimately the court finds that it is coerced debt, the court shall vacate any previous default judgment issued against the debtor, if one exists, regarding the coerced debt. Also, upon such a finding, the creditor shall have a cause of action against the perpetrator. And in addition, the debtor can also seek, shall have a cause of action against the perpetrator as well, if the debtor made any payments or incurred other costs related to the debt. Subsection C, this section shall not be construed to limit or infringe upon any other rights or remedies available under common law or any other provisions of law or rule. And then subsection D, these are additional protections for debtor in a legal proceeding. So if a debtor signs a sworn statement that disclosing the identity of and contact information for the perpetrator is likely to result in future abuse to the debtor or a member of the debtor's immediate family, the creditor may file a motion requesting a hearing to determine the danger of future abuse to the debtor or to a member of the debtor's immediate family. The debtor shall bear the burden of proving by a preponderance of the evidence that if the debtor discloses the identity of and contact information for the perpetrator poses a danger of future abuse to the debtor or to a member of the debtor's immediate family. And if the court finds that this burden is met, the debtor shall not be required to disclose the information. If the debtor does not meet the burden, the court shall order the debtor to disclose the identity and, if known, contact information. And then again, some additional protections in a legal proceeding. Upon motion of the debtor, the court may seal court records in accordance with Rule 9 of Vermont Rules of Public Access to Court Records, redact personally identifiable information, or direct that any deposition or evidentiary hearing be conducted remotely to protect the debtor or a member of the debtor's immediate family from a perpetrator. A debtor seeking a relief from abuse order or an order against stalking or sexual assault shall do so in accordance with Vermont law, as cited there. So the provisions of this subchapter in subsection F I'm reading shall apply in any action brought in a court of this state, notwithstanding a contractual choice of law provision. So if there is the requisite standing, if a debtor is in the state, the contract itself has specifies that the contract is subject to another state's law in terms of its interpretations, its meaning, that these remedies here would still apply. Then subsection G, nothing in the subchapter, shall be construed to preclude a creditor from seeking recourse under applicable law for a claim of coerced debt that is knowingly and materially false. Subsection H, a perpetrator is not a necessary party to an action between a creditor and a debtor under this subchapter. However, no finding in such an action shall be binding on a person who is not a party to the action. So there is a statute of limitations provision. An action by a debtor against a perpetrator shall be commenced within 6 years after the date the debtor discovered or reasonably should have discovered the coerced debt, or within 6 years after the coercion or abuse giving rise to the debt ceased, whichever is later. And then subsection J, with respect to actions by a creditor against a perpetrator, those actions shall be commenced within 6 years after the date the creditor received the debtor's statement of coerced debt and adequate documentation, or received notice of the identity of the perpetrator, whichever is later. So this subsection is just acknowledging that a creditor may not know who the perpetrator is, that information may not have been disclosed. So they would have additional time to seek recourse. The violations here, again, these are violations of any provision that I've just read, which would then be subject to the provisions, the penalties and provisions of the Consumer Protection Act, which is the reference there to section 2453 is the definition of what constitutes unfair business practices, and then triggers all of the remedies under the Consumer Protection Act. So this is basically saying any violation here would also constitute, for purposes of the Consumer Protection Act, an unfair business practice. And again, the Attorney General has the same authority to conduct investigations and bring civil actions as they would under other violations of the Consumer Protection Act. So there's a confidentiality provision. I'm not sure if you want me to go into this in detail, but basically protecting any of the information, personal and financial information of a debtor that might be disclosed in the course of a proceeding or a complaint filed with a creditor. Any privileges, existing privileges would still apply, even if a debtor avails themselves of these remedies and shares information to a third party. So those privileges would not be waived unless expressly waived. And finally, the information is not subject to a public records request. And there's no limitation to that exemption from the Public Records Act. So then Section 2 just is an amendment to Vermont's existing Fair Credit Reporting Act. And basically it just adds a provision. Scrolling down now, I'm on page 20, line 11. This is basically if a report of coerced debt is made directly with the credit bureaus or credit reporting agency, that they, pursuant to the Fair Credit Reporting Act, would have to do a reinvestigation. And then remove the information if it were found to be coerced debt from the credit report. Section 3 is really just a technical fix. This is, again, under the Fair Credit Reporting Act regarding complaints that are filed, and you'll see what's referenced there on line 5 to Title 13, Section 2030. That is the identity theft provision. It's actually more than just subsection A, so now it just references the entirety of that section of law. And so that is the end of the coerced debt provisions. As I mentioned, there's another substantive section concerning protections for banking customers in instances of suspected financial exploitation. So do you want me to go through this one, or do you want just kind of an overview? What would be most helpful?
I think we need to go through that one. I'm trying to figure out the areas that are most specific to our committee. Just going back to my notes here. And I think really our main jurisdiction is basically starts on page 13, really, under the civil legal remedies. And there's one or two other spots, but that was the area that I flagged. And if I don't really have anything beyond that, aside from probably taking some time to figure out what the committee wants to do with that section or with the bill, or if this is a bill that perhaps should be in Senator Clarkson's committee after we made some recommendations here, if any. But I guess that's just more of a comment. Committee, do you have any thoughts or questions? Yeah, we're gonna take some additional testimony in the near future, and so not really sure what else would be able to discuss today, unless you have anything else to provide, Maria.
No, no, I really don't. If there aren't further questions, I think, House Judiciary similarly was pretty much limited its review to the civil legal remedies, as you're suggesting. So, yeah.
Which, can you remind me which committees had it in their possession of the House?
Yeah, so in the House, it was just House Commerce and Economic Development, Chair Marcotte's committee. Yeah, so Judiciary, as I mentioned, did not have possession, but gave some significant feedback to Commerce. So this bill, if you voted out of your committee, it would likely go actually to Senate Finance, because they handle banking provisions generally, so.
Are you able to recall what the suggestions were from House Judiciary and how those were taken by Commerce?
Yeah, I'll try to recall. Michelle Childs also worked very closely with them, so she might have better recollection. But so some of the issues, they wanted to be specific about the statute of limitations and specifically ensure that creditors had additional time to go after a perpetrator if they didn't actually know who the perpetrator was. So that was something that they clarified. They also wanted to make sure that if there were a finding of coerced debt, that the law very specifically said that would enable the creditor to bring an action against the perpetrator. They also, I think the prima facie standard was included in the bill as introduced. But they reviewed that, I think, a little bit more closely and found it to be a sufficient sharing of burdens between the debtor and the creditor. They also tweaked the language with respect to the protections that a court could take regarding the debtor, sealing records, allowing for remote proceedings. That language was a little bit nebulous. Kind of initially, it just said that the court could take action, but didn't specify, that the court should act upon a motion by a debtor, for example. And so just tightened up that language. Let's see. Think, they also, referenced, I'm just on page 15 now, look, lines 10 through 12. Just more specifically, referencing the relief from abuse provisions, so that those were known avenues of protection. I'm not sure if the necessary party provision was there. I think it may have been in the bill as introduced, but they reviewed this language. So, again, if a creditor brings the action to enforce the debt against the debtor, the perpetrator doesn't have to be there. Could be, but is not necessary for a court to make a finding. But then obviously for due process reasons, those findings could not apply to a perpetrator unless they were a party. So it could apply to the relationship between the creditor and the debtor, but not find coerced debt against a perpetrator until the perpetrator had an opportunity to participate in a legal proceeding. I think those were the major issues. And like I said, I believe Commerce accepted all of the recommendations from House Judiciary and really deferred to their expertise. Michelle might remember some additional provisions that were worked out a little bit more closely, but those are at least the main subjects.
Adequate documentation was defined earlier, right?
Yes. So why don't we go back? Because I feel like that's where I didn't understand Senator Brewer's question, and maybe now we can look at it more closely. Yeah, so a debtor can file more than one documentation, but at least one of the three mentioned here. So we'll look at that first one just to make sure I understand what it includes. So again, this is the police report that's filed, that a debtor files with a federal, state, or local law enforcement agency. It specifically identifies the coerced debt and the circumstances under which it was incurred, and is subject to Vermont's penalties for filing false information to a law enforcement agency. So I'm not sure. So the report, it's a police report filed with law enforcement, and the filing is subject to penalties.
So Maria, sorry to interrupt
Yes.
you yourself. I may have answered my own question, which
Okay.
would mean that I don't think we need to make any changes, but when we're looking at adequate documentation, a copy of the report filed, so on and so forth, and then the filing of which subjects the person. Wait. Gosh. Just kidding. I did not answer my own question. So I guess I'm trying to figure out how substantive this police report would have to be in order to be adequate enough to be considered adequate documentation so that they have a prima facie case to begin with, because then it shifts the burden to the defendant. So, I mean, it's somebody can you talk a bit more about what the report would have to entail and what we're talking about when we say identifying the coerced debt and circumstances under which the coerced debt was incurred?
Yeah, so it's a good question. It's not something that actually came up for discussion in terms of just how specific the information needed to be. So it was really just limited to what's seen in the language. So if a debtor actually goes and files the report officially, and it identifies it and the circumstances, there really wasn't discussion about what additional information or how specific the information needed to be. So I'm afraid I can't really shed light on on that subject. I don't know generally when filing a police report how specific and a complainant needs to be.
Area of expertise.
I don't know if expertise. Yeah, I mean, I guess what I'm getting at is, I mean, this isn't really a major concern. It's just more specificity if it's even needed. But I mean, every police encounter or complaint has to be documented. And, you know, in the event somebody provides really just the most surface level of information and it gets put into a police report, then, you know, then they have that adequate documentation, and it may not be, it really may not be particularly substantive.
Yeah.
So I don't know if maybe I'm just overthinking it. That's probably the most likely situation. So.
No, and you know what, why don't I can talk to Michelle and just kind of see if there are other instances in Vermont law just having to do with police reports, and if there are specific circumstances that do require greater specificity for if it's going to be used as evidence in another proceeding. Yeah, I'm happy to look into that further.
That's helpful. Thank you. And so I think I'll speak to the Secretary of the Senate and the chairs and see if and when we can recommit this to another committee, ideally sooner rather than later, just to make sure they have adequate time to work on it. But also just to make sure that there's nothing else that you need to necessarily work on unless the committee raises any other concerns or suggestions. Committee, anything, any thoughts, comments, concerns? Nope. Nothing else here. So, thank you.
Okay, great. Thank you.
Well, just to your question, I'm sort of looking back through it, and like the court is able to weigh in as well as to whether so I don't think it's just that piece of documentation.
Well, it goes to, well, it's one, it says on line 8, page 1, at least one of the following. So it could be the police report. And then if you go to, they have to submit a statement of coercion and adequate documentation. And with that, they'll have a case on its face. And then the burden would shift to the defendant, where they would have to prove that the plaintiff doesn't have a case.
Okay. I was looking at the list, assuming it was, okay.
So, well, but yeah, then I guess there is line 4 that says, well, if the court finds the debt is coerced, but it says there will be a prima facie case.
Okay.
So, I don't know.
Maybe it deserves a little more time.
Oh, great. Thank you.
Thank you.
All right. So we can. Okay. All right. We can adjourn.